right, welcome back to the show, guys. Let's start with the biggest headline. A jury in Wilmington, Delaware, uh, proved me wrong, Mansfield. I predicted that there would be jury nullification, that Hunter Biden would not be found guilty on these 3 felony counts of lying on a federal firearms application in 2018, although the evidence presented by the prosecution, I must admit, was pretty compelling. Tell us what you think happened with this jury and explain to us what jury nullification is and why you think it didn't happen in this case.
Jury nullification is the idea that you don't want the jury to actually focus on the actual charge facing the defendant. You really want to focus on the process and the other factors that contributed to the filing of the charge, and therefore ignore the evidence that the prosecution is going to submit and use your gut and use your intuition and vote your intuition, not the evidence. I think the defense made a mistake by showing the jury that this was a so-called accordion theory. My pages and my picture isn't big enough to do it. The accordion defense. And what he meant by that was, yes, the government had all of this evidence, the size of an accordion, and then he tried to shrink it down and said, but if you just look at just that 1 second when he signed that application, that's the only thing that you have to focus on. Unfortunately, jurors all the time are told, when you walk into the courtroom, you do not leave your common sense at the courthouse door.
Okay, so Bobby, Mansfield says they made a mistake with this accordion theory. What do you think a more persuasive theory by the defense would have been, given that you got 3 women who were as close to Hunter as anyone could be, talking about his pervasive drug use during this period, not necessarily on that day, as Mansfield said, but during the critical period? What could the defense have done differently?
Well, probably a better defense, Areva, would be to try to argue that the statements that were made were not materially false. In other words, they were errors of omission as opposed to commission, and that it possibly were influenced by the fact that he was addicted, and probably tried to play that aspect of it more, like say that, he might not have been taking drugs at this specific time, but let's say he was taking drugs within a certain period of time leading up to him making the statements that he made, which would have influenced not only his willingness to make the attempt to get the gun, but also may have influenced his judgment with respect to putting in what was later, that's jury determined to be false statements.
But it sounds like you're saying intent, like he may have, yes, acknowledged that he may have made the statement, but he didn't intend to lie or to mislead. But this isn't an intent crime, is it, Mansfield? They didn't have to prove intent, they being the prosecution.
It's just a willful conduct crime. And that's what they used a lot of evidence to convict him with. But, when you really look at the jury nullification, you could argue in this case that the prosecution's overloading of all of that information from all of the women in his lives, especially when, I guess it was his former wife or girlfriend that testified that she wasn't a crack addict until she started doing crack with him. I mean, that was the former wife. It was so prejudicial in a sense. There was so much prejudicial information that was used by the prosecution. I'm wondering, everyone, if they actually have a good case for appeal.
Well, I think there's an excellent case for appeal, because the day before this indictment, a 3-judge panel on the Fifth Circuit determined that the statute is so ambiguous because the statute references controlled substance, the unlawful use of a controlled substance. So codeine is a controlled substance. So if I'm at my friend's house and I have a backache because I threw my back out and she has codeine pills and I take a codeine pill, that's a controlled substance, and it's arguably unlawful because it wasn't prescribed for me. And I fill out that form and say, no, I've not taken a unlawful controlled substance. I arguably could be prosecuted under that statute. And the Fifth Circuit said that's too broad, it's too ambiguous. And they refused to uphold a conviction of someone using marijuana in a case involving this language. And we know pending before the Supreme Court is the case about people who have committed domestic violence. Are they allowed to use guns? So we have all this stuff swirling around where Republicans have been pushing for an expansion of who can have access to guns, including people who have mental health issues, including people who've committed domestic violence, and including people who smoke marijuana. Yet you have this pressure on the prosecution to prosecute Hunter Biden in this case of someone who clearly was addicted at some point in his life, had a substance abuse issue. He's now clean, had the gun for 11 days, and didn't use it to commit any kind of crime. It was thrown away by this ex-wife. So I think the appeals opportunities are vast, and likely, again, if it's not, we hate Joe Biden kind of appeal judge, he should win on appeal. But I want to go back to my jury nullification, Bobby. The problem with that is, as the defense lawyer, you don't get up and argue that you want the jury to nullify. You don't get up and say, throw out all the evidence that's been presented, and you have an opportunity to disregard the facts and the law. So that makes it a little complicated for defense lawyers.
No, and they wouldn't want to be put in a position where they were arguing jury nullification, because that brushes right up against the line against attorney misconduct too.
Right.
You have a right to zealously represent your client, but you don't have a right to argue that the jurors should avoid doing their duty in court. You can't ignore juror rules. And so they would never have done that. But I do think you're right, Areva, that jury nullification was something very real here that the prosecutors had to think that might happen. And reading the comments from the different jurors, they all seem to say that they were very focused on trying to follow the law, regardless of who the person was that was being charged with the crime. And they all admitted that they knew that he was the son of the president, but they felt they had a responsibility to follow the law.
Mansfield, let's talk about this 25 years in prison. All the media keeps leading with this. Unless, again, it's I hate Joe Biden judge. There's no way that this conviction leads to 25 years in prison. What do you predict the likely sentence to be for this conviction?
I'm going to go way out on the limb on this one, and I'm going to say that I think that he's not going to get any prison time. I think there'll be a substantial deviation so low from the sentencing guidelines that he's going to end up in the probation house arrest category. And for all the reasons that we have been discussing so far about this particular case. By the way, the Republicans believe that form that he signed is unconstitutional. They don't even want the form. They want to outlaw the form that says you have to, were you intoxicated or were you using drugs at the time you purchased this gun? So I think he has a breadth of grounds for appeal, and he's going to find strange bedfellows supporting that appeal, Republicans.
Absolutely. Bobby, what do you think about it? I'm with you, Mansfield, on the probation. He's going to come in incredibly remorseful. He's sober and clean. He's got all kinds of mitigation. The mitigation is going to be expansive. What do you think, Bobby? You think he serves 6 months, 12 months, or house arrest?
He should do house arrest. The only way he would do any substantial time would be because the judge is trying to make a political statement out of this, where there's really no statement to make. This is not connected in any way to the activities of his father as president. And, any other person in the same position would get probation. And so I think that that's what will happen here.
Yeah, it just burns me up that the media keeps leading with this 25 years in prison, and knowing, and they know, they have lawyers that work for them, so they know that's not even a remote possibility, but it's a headline and it gets people's attention. I've had people ask me, is he going to serve 25 years in prison? No. The answer is categorically no, again, unless there's some judge trying to make a huge political statement. But again, even I think deviating from what others who have been charged with this, with his background, would set him up for a very successful appeal. But he's not out of legal jeopardy. He is facing more serious charges around tax evasion that case is a little, I think, probably scarier, or should be scarier for him even than this case, and could again cause him to be convicted, and there is serious jail time associated with the charges in that case. So when we come forward, we're going to talk about this other trial that's going to kick off in September that Hunter Biden faces around the taxes or non-payment of taxes, according to allegations made by prosecutors. And also we're going to talk about Mark Ridley Thomas. He filed a reply brief to the U.S. Attorney's opposition to his appeal in his federal bribery case. He made substantial arguments, and some legal experts are saying that the U.S. Attorney's Office has switched its theory, that it's no longer relying on the theory presented at trial that wanted the conviction to move forward with this appeal. I'll talk to our legal experts about, is that legal? Can you really do that on appeal?